Hello, everyone. Thank you for joining us today. I see we've got a couple of folks that are first timers to this group. This is the dispute resolution group with World Law Group. For those of you who don't know me, I am Hannah Shea with World Law Group, the one who's sending you all of the emails regarding this session and others related to dispute resolution. We do have one of our firms presenting today at the beginning, and then we'll have time for discussion for folks to give updates. But just wanted to let you know, we do record this session and post it on the website after, so it will be available for you to go back and reference or share with others. I do ask that you take a minute to rename yourselves so that when we are in discussion, we can tell where you're from. You can do so by hovering over your own video, clicking on the three dots in the upper right-hand corner and select rename and just include your firm name, like a few folks have already done. If you have any issues with that, feel free to send me a chat. And with that, I'm going to hand it over to Wendy, who is one of the co-chairs of the Dispute Resolution Practice Group. So Wendy, take it away.
Thanks, Hannah. Hi, everyone. Good morning, good afternoon, good evening. Thank you for joining us at the first meeting for this year. Nice to see so many of you have joined us, and welcome everyone. Before I hand over to Gerard from MHC, I wanted to let you guys know that after Gerard does his presentation, we intend to go around the room to discuss hot topics in each of your jurisdictions. And it may be worthwhile for you to take a bit of time to think about what you could possibly discuss in the course of listening as well to Gerard, right? Hopefully you're able, we would like to talk about some trends that you see coming up in your jurisdictions, or even if not in your jurisdiction, across the world in the area of litigation and arbitration. We like to start off each of our sessions with a presentation from one of our member firms. And it's useful because we get to know the dispute resolution group a little bit better. So if something comes up within that jurisdiction, it would assist us in explaining to our clients, hey, look, we've got a member firm in Ireland, we've got a member firm in one of these jurisdictions, and we know they do great work. And you might be able to give a couple of examples in explaining to your client why it makes sense to reach out to the member firm. So in this case, we have MHC, and Gerard, a partner who heads the the IP department, is going to take us through the firm, explain to us the great work they've been doing in the past year or so, and so we would know what to say in future if something comes up in Ireland. Over to you, Gerard.
Thank you very much, Wendy, for the kind words. And good afternoon, good morning, and good evening, as Wendy said to everyone. It's great to talk to you all. You may be familiar with the firm already. I'm in the head of the IP team, but I'm part of the commercial litigation offering. The firm itself has been a member of World Law Group for quite some time. We are the Irish member. We are an Irish independent firm. We do have offices in London and San Francisco, but that's simply to have an Irish partner, on the ground in key jurisdictions in the Irish work that we do. We're at about 119 partners and just under 600 staff. Our litigation offering is divided into a number of significant teams under commercial litigation, medical law, which would do quite significant medical negligence for state claims agencies, but also a lot of product liability claims. And for example, we're acting for Quest Diagnostics in a lot of litigation around the mishaps around the cervical cancer screening that was taking place in Ireland that you might have seen in the media. Public regulatory investigations acts for state bodies and things like judicial reviews, insurance and risk in insurance disputes, and construction, infrastructure and utilities deals with construction type disputes. Rory Curran, who you may know from the World Law Group meetings, heads up that department, and we do planning and development there. But as far as commercial litigation is concerned, where I'm based, that again has a number of sub-teams: general commercial litigation, which might be breach of warranty, shareholder disputes, IP, technology litigation, restructuring and solvency, which Judith Reardon's in. Again, you might have met her at some of the World Law Group meetings. Property disputes, white collar crime, competition, and data solutions, which is An offering we find is more needed here given the huge discovery that we have in this jurisdiction compared to a lot of other jurisdictions, particularly civil, where we need specialists that are able to sort of do that document support around that. So here is, I won't go through the names, but here is the department by way of partners, associates, and senior associates. I thought it would be useful just to sort of give a look at the Irish litigation landscape by firm, this being the bigger firms. So I'm not afraid to name competitors, but this was recently published in the Currency magazine, where it looked at the Irish litigation landscape. And you'll see that MHC, as far as high court cases, which is our highest court of first instance, we have far more cases than a lot of other firms around the country. Now, there are explanations for that. Like RDJ, there'd be a lot of insurance claims, there'd be a lot of debt collection claims, which some firms mightn't do. But again, we consider, we have a very wide offering, and indeed, we can say we're involved in more cases than a lot of the competition. Just to sort of look at some of the current cases that we're doing, so you can see the type of work that we find dealing with in practice. Biogen and Neurox Pharma is a case. It's a patent infringement and invalidity case. It's one of the Irish patent cases that has sort of a pan-European element to it. There are related proceedings in many other countries. We often find that, and we often find patent litigation happens here because the manufacturing sites are predominantly in Ireland a lot of the time. And that's why Ireland, as a small country, gets to do its fair share of patent litigation. We also have a lot of the social media companies and the like, Meta and TikTok, based at the European headquarters in Ireland. And as a result, the Irish Data Protection Commissioner is the regulator overseeing a lot of what goes on, and then is issuing a lot of decisions against the likes of Meta and TikTok under the GDPR. And there are huge fines that have been imposed that we are currently challenging on behalf of Meta and TikTok in the Irish courts as a result. One of the fines being 1.2 billion in respect of transfers between Europe and the US, which you may have seen. We've also got quite a good aviation leasing sector in Ireland. And as a result, the biggest case that's going through the Irish courts is to do with the insurance claims that have been taken by a lot of companies that have been leasing aircraft that were seized by the Russian Federation at the start of the Ukrainian war, and whether the insurance companies were paying under the all risks or war risk policy. So would you believe there's a 6-month trial scheduled to take place later this year? And we're one of the firms dealing with that. Tumblr and Commission Demand, that is a judicial review by Tumblr, who has been designated as a VSOP by our local online safety regulator. So it's just an interesting case where they're claiming not to be as prevalent in the social media space to be regulated. Dave Fanning and Microsoft, an example of a defamation case. We find those are quite prevalent here as well, because the Irish base of a lot of Facebook, Twitter, or X now, and in this case, Microsoft, are run through Ireland on a European basis. So a lot of claims for defamation and like that would come through the Irish courts. And that's a prime example of that. Ryanair, a very famous airline, low-cost airline around Europe, is taking screen scraping case against a number of online travel agencies, which brings in a lot of competition defense aspects. We're dealing with that. And then finally, there's an SSE Renewables case. It's a sort of a shareholder dispute around a wind farm. There's a lot of renewable energy in Ireland, given we're an island, and you'll see a lot of disputes around the sort of deployment of that and state contracts. So that's just a prime example. So that's just an example of the cases we are seeing. By way of trends, just very briefly, we probably will see more restructuring and insolvency, because a lot of the debt and tax was warehoused during COVID, and our revenue is going to sort of release that at the 1st of May. So we're expecting there to be quite an impact economically. So that might drive some litigation or certainly restructuring through the courts. Then there's the potential for certain companies like OpenAI to set up here as well. So whether there is going to be an aspect of case law around AI and how that is regulated in Ireland. And then we are looking at the introduction of third-party funding, which is to date banned in Ireland as an offence. And if that is changed by way of legislation, we do expect that to sort of significantly increase litigation here, including in particular in sort of class action type actions, which has been brought in at an EU level. So that is a very brief rundown of the firm and what we're at. So I hope that give some insight into the firm.
Philip, did you have a question? You look like you might have a question.
Yeah, I was very impressed, Gerald, about the amount of cases you have, and in particular the increase from the previous series. Is there a particular kind of case which you have with a lot of different files, so that there is suddenly such an increase, or you're so extremely successful in the last year?
I don't think it's a token of our success as such, but there are a lot more challenges to the Irish regulator, for example, and that's not going to explain tens and tens of cases, but we're certainly, that is increasing, and there are a lot of appeals going in on that. I think it's just naturally we're finding more sort of international cases finding their way into Ireland, I suppose, is probably how it's increasing. The litigation here is just getting more complex. We spent years doing a lot of debt enforcement cases due to the sort of financial crash, but now it's become more strategic for Ireland to be used as a jurisdiction, and maybe that's partly explaining why.
Okay, but your competitor must be frustrated because if I remember slide correctly, kind of year before you were kind of even numbers, and now he have a lot of you're much in front of them.
Well,
And Gerard, why is it getting increasingly more strategic to use Ireland as a forum for litigation? Is it because of Brexit?
there, in part, yes. I mean, there is the profession has set up an association called Ireland for Law, which does sort of advocate Ireland as a dispute resolution, as I'm sure other countries would too. Clearly, we're suggesting that Irish law, governed contracts and things like that, and Irish jurisdiction are useful from an enforcement perspective, because we're still within the sort of Brussels regs regarding enforcement of awards and things like that. So there are aspects that we would say are relevant to Ireland following Brexit, for example. Yes, absolutely.
And do you have efficient courts that might be a reason to choose Ireland, or is what?
Yes, we have a commercial court which is 20 years old this year, and it was set up to take commercial disputes with, at the time, a value of over €1 million, or something that would be quite commercial, such as an IP dispute with no monetary threshold. That threshold hasn't actually gone up, but it is a very active case managed litigation, because it effectively, you apply to enter it, you're in court within a week, and the judge is, if it admits the case, is handing down directions for the exchange of pleadings. And the whole aim is to have the case determined within, let's say, a year. We do have an automatic right of appeal, so that can happen obviously in commercial disputes too, to elongate things, but certainly at first instance, in a commercial dispute, we do pride ourselves in speed and proactivity of the judges in getting cases through. The only exception to that would be discovery, which, as I said, is quite intensive here compared to civil law jurisdictions, for example, and that can lead to delay.
And what's happening with the Apple tax litigation? Are you guys gonna still continue to turn away that money?
Yeah, that's, we're not involved in that, I suppose, but it's a sort of an interesting approach. But I suppose I don't know. I suppose it will resolve itself. The government has just taken the approach that it doesn't want the money back, but if it's ordered to be paid back, it'll take it.
And Gerard, quick question. You've obviously in Ireland seen an influx of international and English firms in the last 2 to 3 years. So
Yes.
double-edged sword in terms of increased competition, but it also raises the profile of the jurisdiction. What sort of impact has that had on the local market?
It's limited enough in the sense of, from a litigation perspective, that chart actually of all the firms I'd mentioned, there weren't really any sort of international players on it as such. When they come in, it's usually for a particular sector focus. It could be a funds background. It could be life sciences. You might see it sort of happening in the patent space, but it's not to come in, or certainly hasn't to date, had an impact on general commercial litigation, save for very few examples. Usually the bridgehead is set up and then it's, expanded out. But certainly based on those tables from the last 2 years, you're not seeing a lot of international firms getting, or issuing a lot of high court cases yet. That may change obviously over time as the market gets a bit more saturated and mature.
I'm still trying to wrap my head around the fact that you have 500 plus high court cases, but I saw a listing of the number of partners and associates, and I'm just trying to work out how many files each partner and each associate will need to handle. Bearing in mind, you're also saying that the high court moves at a very fast speed.
Yeah, well, the commercial division of the High Court, as I said, that some of those cases would be, debt collection matters that don't go fast, and obviously there can be a number of files that somebody would have. So this is the statistic that this particular magazine sort of published based on the input from all the firms. A lot of the cases aren't as labor intensive as I'd suggest in the commercial court, but yeah, and again, just to be, I suppose, we've 119 partners, but obviously we're a full service firm, so there would only be maybe a third of them dealing in sort of dispute resolution side of things.
Thanks.
Jared, sorry, Wendy, can I ask one question? Jared, just one question for me. I had was fortunate enough to have lunch with your colleagues Kevin Farrell and Peter Johnson during the Dispute Resolution Week in London last year, and I'm mindful that they were occupied with a lot of that aircraft leasing work. And on the face of it, that obviously is not just isolated to Ireland. I know that in the UK there are still claims being issued on the face of it every single week. Are those guys going to have to spin off into their own different section of Mason Hayes? Because it sounds like it's a sort of stream of work that's going to continue for the foreseeable, particularly if it's being fought domestically as well.
No, not necessarily. They're sitting on the floor here. It seems to be a bit of a black hole, though, in the sense of more people are getting sucked into it, and particularly as it's getting closer to trial. As I say, a 6-month trial is. I think the biggest problem for the Irish court system is actually finding somewhere to house that many legal teams because there's so many parties involved. So that's a logistics nightmare that's currently being worked out. But as I say, there are quite a lot of both barristers and solicitors involved in it.
So as long as they're getting a bit of sleep.
That's it.
Okay. So you have also the differentiation, like in England, that you have barristers in Ireland too.
Yes, correct.
Okay.
And do you
Thanks
have
again, Gerard.
Yeah, sorry.
Sorry, please go ahead.
Do you have the ability to argue before courts, like solicitor advocates, or are the barristers the only one entitled to do that?
We don't have an official title, solicitor advocate. I am a solicitor and I have the right of audience in the courts, absolutely. And I have on occasion done it. It's just that I suppose those who are familiar with the dual roles, you wouldn't be able to do everything in a big case, but absolutely, as far as certain applications concerned, I would certainly do them myself. And that's just an automatic right of audience as opposed to an additional qualification on top of the solicitor qualification.
Right. Moving on, if I can, to our next segment. We do have a number of jurisdictions here, and I think it's great. This is our first meeting for 2024, and we thought it would be opportune for all of us to talk about trends that you see upcoming in your jurisdiction in litigation and arbitration, mediation, any form of dispute resolution. So all of us are kept abreast of developments, just like we now know what cases to look out for in Ireland. I think it'll be helpful at least to understand some of the trends that you are seeing in your jurisdictions. And do we have any volunteers who might want to go first? Be helpful, I think, if we have just a 2-3 minute introduction, and if anyone has questions for your jurisdiction, we can then follow up.
Yeah, and I know I pulled some of you who do have introductions, and we've got quite a big group here today. So as Wendy said, let's try to keep it as brief as possible. And if anybody has any questions, please use the raise hand feature just so that we're not talking over anyone. But if any of those of you who have emailed me, Kent, I know, I'll just start calling people out, Wendy. Kent, I know you emailed
Okay,
and
great.
you have updates. So Kent, if you want to go ahead.
Okay, thank you. So I haven't prepared like a PowerPoint. I will just bring up some new development in China. So there just went through the recent trend, and there are 3 points probably will be of interest to you. So the first one is that China has recently joined the convention abolishing the requirement of legalization for foreign public documents. After the convention is implemented in China, then in litigation in China, the certificate of incorporation or the identity information of foreign parties can be advertised and sent to the Chinese court. But previously it was like it need to be like legalized locally and then certified by the Chinese embassy in that jurisdiction. So the process is more streamlined. But this is only related to the public documents. But if we're talking about the evidence and other things, then it still has to go through the legalization process. So that's the first one. Second one is that CTAC, which is a major arbitration institution in China, and has recently issued a new rule to clarify the disclosing on third-party funding. Third-party funding is, the position is not quite clear under Chinese law, although it's not prohibited. But in the new rule, CTAC has clarified that it should be disclosed to the arbitrator, and if necessary, additional disclosure can be required, things like that. And this clarification is very helpful because previously when there is a third party funding, it sometimes challenged by the other party when the award is enforced in the local court. The third one is the arrangement on the reciprocal enforcement of judgment between mainland China and Hong Kong. And this actually, of course, this facilitates the enforcement, of the judgments between the two jurisdictions. But also, this also like offered another option for international dispute settlement, because previously, if you need to, if you're considering like enforcing against the assets in China, in most of the cases you have to litigate in China because foreign judgment are not usually enforced in China. So basically, a lot of like our clients has to choose arbitration, but for that you need to have an arbitration agreement, arbitration clause in the transaction document already. So but with the arrangement, then one more option for our international clients is that they can choose to litigate in Hong Kong, and then if there are assets in China, then it can be enforced. Okay, so that's my update about China. So I'll be happy to take any questions. Thank you.
Yeah, Kent, maybe because you spoke about acceptance of awards from Hong Kong in China, I just read like yesterday or 2 days ago about this decision in Hong Kong about Evergrande. So what is your expectation will be? This is really a decision which China will enforce, or do you see that more in a skeptical way? I don't know if you have a view on that.
Definitely the court judgment, if it's rendered by the Hong Kong court, it'll be enforced according to the new arrangement. And actually a lot of practitioners in mainland China were excited about this, because that means more business opportunities for them in China.
Right. Thanks, Ken. Perhaps I can move on to, I think, David, you mentioned that you might have some updates from Canada. And good speaking with you. We spoke earlier or last week, but good speaking to you now.
Yes, indeed, Wendy. Just a very 3 short updates that I'd provide. We are seeing the courts consistently favor arbitration proceedings if the parties have an arbitration clause. Canada obviously is a very arbitration-friendly jurisdiction, and we're seeing courts consistently across the provinces stay court proceedings in favor of arbitrations. We're also seeing a development, and Louis Martin may be able to speak to this a little bit more, comes out of Quebec, where non-signatories to arbitration agreements are sometimes being compelled to arbitrate if we are seeing their role of the non-signatories as acting as an agent for the principal. We're seeing development that actually is binding non-signatories to arbitration agreements to arbitrations themselves. To Gerard's point around litigation funding, we have a wide acceptance throughout Canada of litigation funding. I know it's developing in Ireland, and it does open the floodgates in terms of proceedings that have been commenced. We have different courts needing different levels of disclosure regarding a litigation funding agreement. We're seeing the requirement in class actions where there's a huge influx of litigation funding to be disclosed, as well as we see arbitrations requiring the disclosure of litigation funding. But some courts, including the Federal Court of Canada, don't require litigation funding agreements to be disclosed up front. But litigation funders and other financing products are coming to Canada in droves after the event. Insurance and other types of products are growing in appetite throughout Canada. And I would just briefly say that on the competition law front, there have been some amendments that have come into force on the Competition Law Act, which is allowing private litigants to now raise concerns over anti-competitive behavior and to seek damages as a result of anti-competitive behavior. In the past, this was left for the regulator to handle and was to be determined in public domain. Now that private litigants have the right to bring claims as a result of anti-competitive behavior, we're expecting potentially droves of litigation to arise as a result of that. So those are just the 3 developments focused primarily in Ontario, Canada, where I'm located, but does have some impact throughout the country.
Yeah, and thank you, David. If I can follow to complete the Canadian segment. Yeah, it's an interesting development, the ability to bring a third party into arbitration proceedings. It's a little bit of the exception. Historically, at least in Quebec, it was very hard to do that, but that exception for the agent remains to be seen how open it's going to be. But yeah, there's a crack in the like that seems there's at least an opening to that. The other and it's David said is very comprehensive. Maybe one additional point to add is courts now are starting to implement guidelines and requirement about the use of generative AI in pleadings and proceedings. It depends. Some will require full disclosure, others don't really care. Remains to be seen what's going to be the general rule. And like my development and the question I had is like, we're looking into numerous generative AI softwares to see what's the best, what's the most appropriate for law firms and litigation in particular. We're testing Harvey right now, which turns out to be pretty, even if it's essentially designed by corporate lawyers, it actually is a pretty good litigation drafting tool. We think we're looking also into co-counsel. I was wondering whether you had looked into any other generative AI software which you think is worth looking at and testing within the firm.
I'm not totally up to date as to which software we're looking at. We do have some people with Ed Goodman's that are looking into that, and we should take that discussion offline with Martin if there's something I can share that might advance where you guys are going with it.
Yeah, but my question was also more general to the entire group.
And Louis Martin, I know we have a number of firms who are using Harvey right now. For those of you who are interested, we do have somebody coming from Harvey February 14th at our business development committee meeting. I'll drop a link to that in the chat if you guys are interested in learning more about that and hearing from some of our members who do use that platform.
And I would encourage you to do that, like all of you. It's actually pretty impressive. Like you could just type, like, write me a demand letter to so and so, telling him that like he owes us $150,000 for unpaid invoices, and if we don't get our money, we're going to sue him. You put literally that, and it's going to draft you a fairly good and descriptive letter. It's very bad at law. Don't ask it any legal question. It's going to invent you legal, like statutory provisions and the like, but it drafts as a lawyer extremely well, and it reviews and revises like cases, provides summaries. It's extremely impressive.
And it's for non-native English speakers, it's also a very good way to kind of improve the briefs. That's also a way how you can use it.
Yeah, and it writes in a number of languages, like French, English, like it will translate extremely well. I'm sure many of you use DeepL. Like it translates better in a legal setting than DeepL does.
Our experience is that DeepL is quite good if we use it, for example, for German to English, but it has not the same level if you use it between Italian and English, or between French and English, or French and German. It has not the same quality. Sometimes the translations are really funny.
Right. Perhaps moving from one sea to the other, Costa Rica. German, sorry, I'm not quite sure. I don't want to I'm quite sure I mispronounced your name.
It's Herman with an open G.
Herman.
Herman, yeah.
He's German.
I was quite sure it wasn't German. I just wasn't sure what it would be.
Yeah, it will be the equivalent of writing it with an H. That's the easiest way to explain it. So no, good morning, everyone here. Well, I mean, I'm just starting the morning here. So, no, when you're asking us for new developments, updates in Costa Rica, I'm sorry.
Yeah, so trends, what are the hot topics you see coming up in Costa Rica?
Okay, so we're receiving, you know, there are in arbitration. I think that what is increasing is arbitration due to construction development projects. So we have like two main areas in this. Is after COVID, the construction sector regained traction, and we have been receiving a lot of conflicts related to construction related projects in infrastructure, and for example in housing and in projects of the office buildings, to say somehow, but in major construction projects and buildings, for example, there were just recently an arbitration regarding a project that was a building that was 20, I think it was like 40-story floors high, and they were with a it was a big project, and became a litigation. So from the construction side, there are a lot of litigation. The other thing that has been increasing is litigation related to foreign investment projects, for example, with government projects. So we have a new, not necessarily a new president. He's in a year and a half in, but he entered with a bit of a populist vein, and he initiated by saying that he was going to fight the foreign companies that were taking advantage of the Costa Rican system and so forth. So he has been very strongly fighting companies that have, for example, government contracts. So there was a large company that had a contract for the last 25 years in Costa Rica. All cars have to go to a revision by the state once a year, and this was done by a foreign company that had been doing it for the last 25 years. He came in and immediately withdraw the contract, and that started a litigation. So there has been a lot of back and forward between the government and companies investing in Costa Rica. There's a project with a Chinese company that was building a road to the Caribbean as well. So there's a lot of those kinds of arbitrations as well. And finally, there's a lot of development as well in the criminal sector, because of a law that establishes criminal liability for corporations. So there's a big case involving 16 companies that are currently in litigation for corruption. So there's a lot of development as well in companies developing compliance programs and anti-corruption programs, just to try to cover themselves because of these new regulations.
Thank you, Herman.
My pleasure.
Perhaps then, if there are no questions, Tom, I understand you might have some update from England.
Yeah, thank you, Wendy. Very, very quick update from England. I mean, there are a number of the trends that have been mentioned in other jurisdictions that we're seeing here. So in relation to litigation funding, some changes there, ESG claims, which I know my firm and others spoke about last year, AI, these are all developing interesting areas. But the bit that I was sort of thought might be of particular interest to those on the call is just something that, particularly in sort of my practice area, I've been seeing quite a lot of recently, which is the rise in supply chain disputes and issues that have been caused by virtue of the numerous things that have been happening in the world over the last few years, I think exacerbated in the UK by Brexit. And the lag that there's been in, and then sort of being able to re-sign up to all the wonderful reciprocal legislation that we were party to and are no longer party to, and we're trying to play catch up very slowly, seemingly. But as a consequence of that, there are a lot of supply chain disputes, and resolving those is becoming increasingly difficult, particularly in certain sectors where, for example, the automotive sector, where you have a just-in-time supply chain, where typically manufacturers are only acquiring the supply they need, just because that's the nature of the industry. And then all of a sudden, if that goes wrong, it's causing big issues. So that's an area where we're seeing a lot of issues, and that's actually an area where we're really needing to lean on member firms and firms around the world to assist us when it comes to dealing with international counterparties. So I thought that was, I can't pretend that's a sort of huge macro trend being felt by every firm across the country, but it's certainly something that we are seeing, and particularly given the nature of the businesses we have historically and continue to act for. And so I thought it was something that might be worth mention on this call.
Thanks, Tom. If we have no other volunteers, then I'm going to call on people that I have reached out to recently.
We do actually. We have a volunteer.
Oh, we do. Do we have another volunteer?
Yoko.
Yoko, yeah, exactly. I was gonna call her. I just reached out to her. So promoting our referral network within WLG, and we'll start calling on people whom I've spoken to recently.
Yeah, thank you very much, Wendy. Hi, nice to see everyone. I have just a very brief update from Japan. The arbitration act in Japan has been recently amended, and there's some changes. But the biggest change is that the new law, new arbitration act allows the arbitration-related cases to be accumulated in Tokyo District Court and Osaka District Court. And the background of such change is that, unfortunately, there has been not so many cases, arbitration-related court cases in Japan. So the idea is to have certain, judges to be experienced in Japan in arbitration cases, because it is kind of impossible for now to have all the judges to be familiar with the arbitration, and to make sure that the arbitration is correctly understood by those judges who deal with arbitration. And the other change that is implemented is that the new law allows the foreign language document to be presented with a translation in such arbitration-related cases. And unfortunately, it doesn't mean all the foreign languages. It is basically limited to English, I think. But that's also a big change in Japan, at least the English documents to be brought in as an evidence with a translation, which has been kind of huge burden so far. So that's a brief update from Japan.
Thank you. Do we have updates, trends from any other jurisdictions?
Yes.
Tony, please.
Yes, hi, good morning, everyone. It's a pleasure and a privilege to be here with you all. This is my very first meeting with this very distinguished group. So I'm currently in New York. I'm working from our rep office here in New York, so I'm close to some of you. So hopefully we can connect. As in terms of developments in Brazil, we have seen quite an uptick in challenges to arbitration awards in Brazil due to disclosure issues with the arbitrators. I think this is more a function of the success of arbitration in Brazil. Courts still are very receptive to arbitration awards, but because of the increased number, especially in the past 10 years or so, we have seen a lot of annulment cases. So whenever a big case or a big award is set aside, of course, everybody knows about it. Everybody comments on it. So there's a feeling that, oh my God, the judiciary is turning against arbitration. It's not our view. We rely a lot on the judiciary to enforce arbitration awards and to do some course correction when necessary. Of course, there are some cases there are outliers, but in general, we still have a very supportive judicial system in Brazil towards arbitration. Most of the cases are still domestic. Most of the transactions happen in Brazil. The assets are in Brazil. So clients, even our foreign clients, prefer to have arbitrations in Brazil, sometimes in English, which is quite fun to argue a case in English before a panel of 3 Brazilian arbitrators. But it's also interesting that we've seen some other investments coming in Brazil. We are a full service law firm, so I review most of the arbitrational clauses, and we are seeing some seats abroad as well, which is also fun, especially for us who want to fly and argue cases outside Brazil. But still, most of the cases are in Brazil, and the judiciary still upholds most, if not all, of the arbitration awards, with some exceptions which are corrected accordingly. Again, very nice to see you all, and I've been learning a lot in this call. Thank you.
I think an emerging trend across all jurisdictions is arbitration-related court litigation. And certainly we do see a lot of that in Singapore as well. So that was going to be my update from Singapore. But maybe I'll hold that back first and see if there is anyone else who wishes to speak on their jurisdiction.
Yeah, Sandhya here from India. Sandhya, I'm from Vaish Associates.
Hi,
Based
hello.
out of, hi. I'm based out of Mumbai office of Vaish Associates. So one update that I wanted to give was in India, our British era laws, that is Indian Evidence Act, Criminal Procedure Code, as well as Indian Penal Code, they have been replaced and they've been given a sort of Indianized names. We have retained a lot of the British era sections, but there has been a lot of streamlining as well, because these were old acts. The fines were very small, and so the fines have been increased. The imprisonment has been rationalized, and they've provided for these new age IT offenses and cybercrime offenses, electronic evidence, and so on. So this is one major change. It has been approved. It has received presidential assent, but the date on which it takes effect is yet to be notified. So once it's notified, maybe in the next session, I may be able to give more updates. And apart from this, I just wanted to mention one trend. I would not say litigation funding has taken off in a very big way in India, but still in our insolvency matters, we see a lot of interest in acquiring disputes, in the sense if there's a particular customs litigation or is there an insurance claim litigation, we are finding buyers for these sort of assets piecemeal. So this is one trend that we've seen in several insolvency matters. So this was the update that I had from India.
Thanks, Sandhya. Is there anyone else?
Thank you. If not, then maybe I could just briefly touch on Singapore. I did say the trend has been and will continue to be arbitration-related cases. In terms of arbitration, two particular updates. The SIAC is revising their rules. For those of you who are familiar with the SIAC rules, they've been around since 2016. The SIAC does plan to roll out new rules this year. It's been doing rounds and rounds of public consultation, some pretty interesting features in the new rules, potential new rules. So once you see it come out, I have no doubt it's going to be the subject of a lot of discussion amongst arbitration practitioners. Second, with Singapore being the seat of many arbitrations, inevitably you're seeing a lot of challenges being brought before the Singapore courts. An interesting case law arising out of that as well. We've had our Court of Appeal decide on whether arbitrators' deliberations can be the subject of a discovery request. This arose out of the fact that one of the arbitrators wrote a dissenting award saying that he had been kept out of deliberations between the other two tribunal members. And one party then sought to use that to apply for discovery, didn't get the discovery because the court basically said, well, arbitrators' deliberations, just like judges' deliberations, should be kept confidential. And we do have to protect confidentiality, save in very, very exceptional circumstances, which they didn't find made out in that case. We've had cases coming out affirming issue estoppel. When you're enforcing in Singapore, issue estoppel if a decision has been made in the seat court. So the Singapore court has confirmed that it will give primacy to the decision arising out of the seat court. We will expect to see a lot more coming out of this area. The other trend that you will see in Singapore is, well, essentially Singapore, we hardly have domestic litigation in Singapore. Everything that comes here, it's multi-jurisdictional because Singapore is essentially a small city, but we have connections with around the world. Around the world, people come to Singapore to do business, just as you come to Singapore to do, have your arbitrations heard in Singapore. And what arises out of that is we're seeing a lot of multi-jurisdictional cases coming before Singapore courts, which then gives rise to jurisdiction fights. So you're seeing fights, people trying to stay Singapore court proceedings on grounds that there is another more appropriate forum. You're going to see more use of anti-suit injunctions. You're going to see people trying to use the court to get around arbitration clauses, which might be, agreements between only limited parties. And someone's trying to come to Singapore to make use of Singapore and some of the tools available in Singapore to get around the arbitration clauses. So we're going to see a lot more of those fights in Singapore. I mean, I personally handled quite a few already just this year alone. So those are the updates from me from Singapore. And if there is no one else, perhaps what we can do, it's just have everyone say hi and tell us where you are from. You don't need to get into updating it about hot trends from your jurisdiction, but at least we get to hear you and hear your voice and know where you're from and how to pronounce your name, which is the greatest difficulty I have now with all the names I'm seeing on the screen. If we can just go around.
Wendy, I can go ahead and call on folks. Just sort of run down my list as
I see a hand being raised by.
Yeah, I see Demetrius real quick. Hello, Demetrius.
Hi. Well, I rushed to raise my hand because my name is the most difficult of all of yours. Which only Daniel Evecti could pronounce my name because he knows my name. Otherwise, it's Dimitris Mvalomenos. I mean, not even me. I can pronounce it correctly. Hi from Athens, Greece. I'm very pleased being with you today. I handed out to Hannah yesterday a kind of questionnaire. We are assisting the Minister of Justice in the revision of the Code of Civil Procedure and ADR regarding mediation. So perhaps next time or any other time that we meet, we can think about and discuss issues such as whether parties and why prefer litigation towards ADR mediation, whether which is more expensive than the other, more time consuming, what has to be done, what is the best interest of the parties, and so on. So this is for the time being, and I'm very pleased I have joined this group today. Thank you.
Thank you, Dimitri.
Well,
I'm just going by difficult names. Sorry.
Yeah, I'm just going around on my list on Wendy, if you don't mind.
Please do, Hannah, please.
Sure, Tyne. And of course, tell us if we say your name wrong.
Actually, she was the person I was going to go to because I wasn't sure how to pronounce her name.
Okay, well, my name is Tine P, and I'm based in Copenhagen in Denmark. I'm specialized within dispute resolution, but within construction. So yes, that is my introduction.
Thank you, Tine. Albin from Södervals?
Yes, perfect pronunciation. Thank you. Albin Larsson. I work at Södervals law firm, and I work in our Malmö office that is in the south of Sweden. Yeah, thank you for all the presentation today, and especially thanks to Gerard. Very interesting. Thank you.
Thank you. Gabriela.
Hi, good morning to everybody. Well, my name is Gabriela Carissimo. I'm from the Dispute Resolution Department in Alfaro Abogados in the city of Buenos Aires, Argentina.
Thanks, Gabriela. And I think that you have a colleague with us today as well, Sabrina?
Yes. Sabrina.
Yes, hi, how are you? Nice to meet you. I'm Sabrina. I'm with Alfaro Abogados as well, and I work with the compliance team also in Buenos Aires. Thank you very much for the very interesting presentations.
Thank you. Rafael, we heard from your colleague.
Hi, everyone. Yes, Rafael Menissa from Tosini Freire in Brazil. We also have Tony here. He made some comments on the Brazilian scenario. It's good to see you all again. Thank you for the presentation. Really interesting.
Thanks, Rafael. Neil.
Sorry, my mouse wouldn't work. Good morning, everyone, or good day. Neil Wilco from Miller & Martin. I am in the construction group here, both litigation and transactional. I work with Ryan. Most of y'all know Ryan, who I see down at the bottom. Ryan is one of our international litigators, but it's great to see you all. Thank you.
Ryan, feel free to say hello. I think most of us know Ryan.
Yes, good afternoon, good evening, good morning, everybody. My name is Ryan Kurtz. I am also with Miller & Martin in our Atlanta office in Georgia in the United States, primarily practicing in the area of litigation and in arbitration. And it's a real pleasure to have such a great turnout and to see everybody. Thanks everybody for joining.
Thanks, Ryan. And I'll go to our colleagues in Italy. We've got Daniel.
Hello to everyone. My name is Daniele Vecchi. I'm working for Gianni Rigoni. I'm in the litigation department. And there is also my colleague Michela Turra, which is working with me in the litigation and specialized in product safety. And as a matter of fact, she has worked quite a lot with the people of Mason. And congratulations for the presentation. It was very useful.
Hi everybody, this is Michela Turra from Gianni Rigoni in Milan. Thank you, Daniele, for introducing me. This is my first time here. Thank you very much for this opportunity. Hope you'll have the chance to see each other again in the near future. Thank you very much.
Thank you, Daniele.
I think Daniele was too humble about himself. So if you have any collective redress issues, then Daniele is definitely the right address in Italy too. I know that.
Well, thank you, Philip.
Thank you. Roberto from Mexico.
Hi, everyone. Very nice joining you today. Hi, Wendy. A long time not seeing you. I'm in from Santa Marina Esteta in Mexico City. I'm in a dispute resolution practice area. My practice is focused on civil and commercial litigation, also arbitration and mediation. There's a lot of things happening here in Mexico. We have a new mediation law just published last week, and where there's a new national procedural civil rules, which are we've already been published, but are still not applicable. And our government is doing a lot of crazy things against certain investments especially in the energy sector. I offered to prepare something more thorough for the next opportunity. I'm going to be able to join you. So very nice seeing you.
Thank you, Roberto. And we have our colleagues here from Sanko Karenko in the Ukraine. They have just joined the network as an observer firm. Tatiana?
Hi, everybody. Very nice to see all of you, and I'm really happy to be part of today's meeting. Thanks for presentations. My name is Tatiana Slipachuk. I'm an international arbitration lawyer and also have the head of the board member of the Ukrainian International Arbitration Court located in Kiev. And probably maybe next time, if you would be interested, I will be happy to discuss with you the peculiarities of how to provide arbitration during the wartime, what things have been done by the institution in order to ensure the case proceedings, what challenges face our arbitrators, including foreigners, during the air raid attacks, etc. And also, just to mention that despite all these peculiarities, last year, the International Arbitration Court in Ukraine managed to take into consideration around 600 international arbitration cases. And we have very interesting development in the field of the military goods procurement disputes, which actually now are concentrated in Ukraine and several other institutions. So we have our own peculiarities, fortunate or unfortunate, but we have them and we tackle with them. And for me, very important to have this possibility to share with you the experience and to hear from you the developments in your jurisdictions. I'm here with my colleague, Alexander Druk, who is the partner of international arbitration practice of our law firm.
Hi everyone, also very happy to be here. It's my first meeting. And as Tatiana said, there are many challenges, but the courts continue to work and there are arbitration matters continue to go on. I am also a board member of the Ukrainian Arbitration Association, and as part of our activities, we do submit amicus curiae briefs to the Supreme Court on various arbitration-related matters. And recently, some of these amicus curiae were taken on board by the Supreme Court. So it's a good direction that the Supreme Court is trying to hear from the professional community, and the stance that it takes in recent judgments is quite pro-arbitration. So also would be happy to share this recent experience.
Thank you, Tatiana and Alexander. And I think last but certainly not least, we have Liam with us from the Cayman.
Hey all, Liam Faulkner from Cayman and BVI. We're seeing a lot of arbitration enforcement matters. Obviously, Cayman and BVI tends to be where the assets are located or held through these sort of structures. We're doing a lot of work in terms of injunctions, asset preservation orders in support of ongoing arbitrations, enforcement of provisional awards. We're also doing a lot of enforcement of final awards. I've got one next month, which is being disputed on the basis that it arose out of the parties had agreed to arbitrate in accordance with the IFC LCIA, which was abolished in 2021. So our clients gone ahead with a DIAC, the replacement body, looking to enforce the award, and it's being disputed on that basis. I think that's the first time an English law governed arbitration will be determined on that basis. There was a US judgment a couple of months ago, but we're looking pretty good on that. General trends, we're seeing a lot of distressed oil and gas, particularly in the Middle East. It tends to be the case that people had borrowed large amounts of money. There was a willingness to forbear payment during COVID and post-COVID years, and the patience seems to have run out. So we've had about 5 or 6 winding up petitions in the last couple of months, mostly coming out of Middle East. I think there was one PRC one. And in terms of trends, we're also seeing a lot of litigation financing. So particularly where we've got frauds or large-scale frauds, obviously the fraudsters don't leave any money behind to fund professional fees. So we're seeing a greater willingness to take on contingency-based work, including taking percentages. So up to sort of 25% of recoveries is what our rules provide for. We had a very good result earlier, late last year, on a $90 million judgment for liquidators against Deutsche Bank in the US. Again, that's all done on DBA, so taking a percentage of recoveries made. So we expect to see more of that sort of work. Our firm in particular has got a real interest in it, not least because we've had a couple of decent wins. I think the test will be when we lose one and make no recoveries. But at the minute, things are going well.
Great,
I think we forgot Mark Lee, if I'm not wrong. You're still on mute, Mark.
Good evening, everyone. It's nice
Hi,
to
Mark.
see everyone and hear the trends and hot topics in other jurisdictions. Thank you.
Thanks, Mark.
Thank you very much. And also, Hannah did not really introduce herself. She's kind of a crucial part of our group. She always organizes, kind of reminds us of the dates. And thank you very much today for both Tatiana and Roberta coming forward with suggestions for the next events. I've taken note of that. And also, if you have other ideas, or you would like Jared did for Mason today, give a presentation of your dispute resolution team, please reach out to us. And if you don't remember the names of Wendy, Ryan, and me, you're also most welcome to send an email just to Hannah, and she will certainly forward it to us.
We chose the leaders on the basis of our easy to pronounce names, so there's no reason you cannot remember us. But I mean, jokes aside, our next meeting is on the 9th of April. So if you could just jot it down, 8 a.m. Eastern time. Obviously, Hannah will send around a reminder ahead of time. but it's helpful since we have all of you here and such a wonderful big group of us today from so many jurisdictions. Our next meeting will be on the 9th of April. As Philip says, if you have ideas that you think would be useful for us to talk about at that meeting, do reach out and let us know.
Yeah, and I just dropped the link for that meeting in the chat, and I will also circulate to everyone who attended today a list of email addresses for everyone who was here in case you wanted to follow up on any of those conversations. So you'll have that easily accessible. But again, thanks everyone for attending, and don't be shy about reaching out to each other, but the leaders or me, of course.